9-339, State of Tennessee versus Kenneth DeHart Jr. Could you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Mr. DeHart, you are before the court having been indicted by the Blount County Grand Jury for first-degree murder, attempted first-degree murder, felon in possession of a firearm ×2, felon in possession of a handgun, employing a firearm during the commission of a dangerous felony ×3, possession of a firearm contained in dangerous felony, aggravated assault against a first responder ×2, reckless endangerment, tampering with evidence, evading arrest with risk of death or serious bodily injury, aggravated assault, resisting arrest, and failure to maintain a lane. Do you have a copy of the indictment?
We do, Your Honor.
All right, do you waive formal reading of the indictment?
We do, Your Honor.
And Mr. DeHart, did you fill out this affidavit this morning?
My attorney did.
And is that true and correct?
Yes, ma'am.
Okay, and at this time then, I will reappoint the Office of the Public Defender to represent you. We need to set some dates.
We do.
So at this time, it's the court's intent to set a scheduling order with deadlines. The offense date on the indictment is February the 8th, 2024.
Correct.
So I'm assuming, General, that there are still stages of the investigation ongoing?
There is a lot of testing still going on, Your Honor. A lot of lab results still going on. That's correct.
And I'm assuming then you've had the case in Sessions Court, is that correct, Mr. Elrod?
Yes, Your Honor.
So I'm assuming that you are also in the process of conducting your own investigation?
We are.
So the court is going to set some deadlines in an attempt that when we are back in court to set trial dates, that everyone is going to be ready for the case to be set for trial. If you could, with your calendars, would August the 16th work as a discovery deadline?
Yes, Your Honor.
That works for the state, Your Honor.
So I'm assuming that you've not filed your Rule 16 motion yet. Is that correct, Mr. Elrod?
I filed it yesterday, Your Honor.
Filed yesterday. It hasn't made it to the court file. Okay, so then we'll be in compliance with Rule 16. Your deadline will be August 16th. Obviously, I would expect that the state continue its policy of ongoing discovery.
We've already started delivering discovery, Your Honor, and we'll be just delivering it as it comes in.
I think that would be helpful rather than it occurring all at one time. So if we could do that, that would speed up the process. As far as motions and notices, would September the 13th work as a deadline?
Works for the state, Your Honor.
Yes, Your Honor.
All right. And then should the state seek enhanced punishment, including death penalty or life without parole, I'm going to set October the 11th as your deadline.
Thank you, Your Honor. That works.
And then after that October the 11th deadline, should the defendant seek to change venue, the venire panel, or disqualify the court or the DA's office or any other party, November 15th?
Yes, Your Honor.
Yes, Your Honor.
All other motions would be filed no later than December the 7th?
Yes, Your Honor.
Yes.
That works. And then you would be back in court on December the 13th, at which time the matter would be set for scheduling of the jury trial.
Yes, that's
Yes, that
agreeable.
works, Your Honor.
Do you believe that with the investigation and the amount of discovery that you're going to have to exchange, do you believe that those deadlines are realistic?
I think
do,
so.
Your Honor. Yes. The state has already requested to expedite all testing, so it should be to the top of the queue as far as the Tennessee Bureau of Investigation is concerned. So I think that should give us sufficient time to have everything tested, done, and turned over to the defense for their review and analysis.
Obviously, if there are any constitutional issues that need to be brought before the court, those can be filed without concern about the deadlines.
Sure.
It appears from the file that Mr. DeHart was bound over that there was not a bond set initially in this case.
That's correct, Your Honor.
So upon indictment, the case was brought before the court and a bond has not been set. Would like to address that for the purposes of the record, Mr.
Sure.
Elrod.
At this point in time, Your Honor, we're not asking, we've not filed any motion requesting that the court set a bond. Again, we're in the process of our investigation and discussing several different things. So at this point in time, we're not making that request. Should that request be known, I will file a motion in writing.
Okay, because that is a constitutional issue.
Correct.
Mr. DeHart, has that been discussed with you?
Yes, ma'am.
Okay, and you have been afforded an opportunity to speak to your attorney about that decision?
Yes, ma'am.
And you agree with that decision?
Yes, ma'am.
Okay. Is there anything further for the purposes of the record?
I don't believe so, Your Honor. I think that covers it.
Okay, do you want an extra copy of the indictment?
I've got a copy of, I've made a copy of that as well as our discovery motion and a few other things that court personnel have already taken a look at. I'm gonna be able to go back and speak with Mr. DeHart and give him those items today.
I think Mr. Elrod and I did discuss with the court's permission that all motions should be done in writing. All motions should likely be responded to and likewise in writing, just to make the record as clean as possible, going forward.
Absolutely. And if there's any other matters that need to be brought to the court's attention, we can set it on the docket at any time.
Sure.
In the meantime, it is my understanding that Mr. DeHart is housed in another county,
That's correct, Your Honor.
and so I'm assuming that you're going to have many meetings with Mr. DeHart.
Yes.
So if there's any issue, that can be directed to the sheriff's office for you, for any arrangements to be made for you to have access to your client.
Yes, thank you, Your Honor.
Okay, anything further?
No, Your Honor.
All right then,